Are we ready to go? We're on the record in case D430049, Victoria versus Victoria. Counsel, what do you have to report?
I'm a little confused on the terms. I think we have an agreement on some things. But if Your Honor could recall,
I have a lot of notes about it, Counsel. I know we had a discussion regarding Seven Hills Hospital arrears. We had child support arrears from April 2019. And we had other issues about the classes that were suspended for UNLV. I kind of have a lot of notes on this one, so.
So we were just discussing the child care expenses, and my recollection was that we had a stipulation that it would be shared equally between the parties.
Okay, let me look and see what I've got on here. On my notes from last time, the defendant shall pay half the cost of the child care fees, or what we had in my last minute order on March 17th, 2020. That's what I had in my order, or in my minute order. Do you need a little more time, Counsel? I can certainly break for lunch, let my staff go lunch, and then we can come back if it'll help.
Yeah, I don't know how much further we can get than where we've gotten now.
Okay. Do we want to put on the record what we have, Miss Robinson, or what are we doing?
Yeah, let's go. I agree with Franny. I don't know that we can get much farther, and I guess we'll be bringing to the court a new issue. In regards to the pending issues of sole legal custody, the parties have stipulated to a modified joint legal custody arrangement, wherein Marnie will be making the medical, religious, educational, healthcare decisions, and she is to notify Victor. She's to keep him in the loop of everything. He should still have access to all of the records. She should notify him of the decisions that she is making, and when emergencies come up, or maybe travel comes up to a dangerous country or something that he might perceive as dangerous, she needs to timely notify him so that he may go file a motion with the court on any legal custody issues he may have.
Okay. So she's basically had decision making with notice to Dad, with Dad having the ability to file a motion if he finds it to be a dangerous or concerning situation. Is that it? Have I got it clear?
Correct.
Yes.
Okay. All right. The next issue, Counsel?
The arrears, I guess we didn't fully decide on the arrears. And maybe if the court could give an opinion as to the arrears. The parties have gone back and forth about wanting full, entire payment and all of that. And our position was, Victor's position was, their arrears only date back to 2019. They don't have a big established history of arrears. We don't want to go to trial over $4,000 on arrears. Do you know what the court might order in that type of situation? Because we understand what the 30-30 rule says, and Victor's position this whole time was that Mom switched up the way she was notifying Dad about the medical expenses.
And this is the bottom line. This is the bottom line. If the child went for medical care, and the big issue before me originally was Seven Hills. And if Mom notified him that she's taken her, that's an emergency kind of place. You don't just like, they're having a bad day, let's put them in Seven Hills. It's not that kind of situation. I remember from the last hearing, there was a lot of discussion about whether the doctors would have sent him and all of that, but the child went. And that, if I remember, that issue was only like a $670 issue.
Right, so that's actually not even
the problem?
The issue, Your Honor.
Okay, so that part's resolved.
That part's resolved, but what they want is the entirety of the medical bills, because they're saying he didn't pay under 30-30, and therefore they're entitled to 100% cost.
No, I wouldn't do it like that, because there was a reasonable dispute that they had. I would say he's going to pay half the bills, just like half under the 30-30 rule. That would be my order on that. If I have to go to trial, if you're going to prove, you've got to prove that it falls within the case that we are the stipulation or the order that I have before me in this case that says they're going to do it on the 30-30 rule. Is that correct, Counsel?
Right, and so what we're saying is she did provide him the notice within the 30 days. He failed to pay her like now at this point we're a year and a month out, but he failed to pay her back within 30 days. So therefore she has the right to go after the full amount that she paid in addition to attorney's fees and due to his non-payment.
Okay. Due to the non-payment, I'm likely to grant attorney's fees. I wouldn't grant it to be the full amount. I would likely grant it. I mean, I'm just speaking out, telling you how I think. It doesn't mean this is an order or anything like that if it helps you guys resolve this matter. I'm likely to grant her half, of course, the half that she was entitled to, and attorney's fees for having to bring it before it, because that's ridiculous. If the fight is that the child, the doctor thing, certainly both parties could have brought it before, and I think that's, the child clearly needed something, or we wouldn't be putting a child at 7 Hills. So.
Well, and we're not even talking about the 7 Hills. We're talking about all of the unreimbursed medical expenses that.
Well, that was one of the unreimbursed at the time, if I recall. Right? Wasn't that one of them?
Yes.
No, the 7 Hills occurred after we filed our initial motion.
Okay. All right. So for all of it, so Ms. Robinson, why is your client not paying his portion of the medical expenses?
Well,
What's
as
his
the court
position?
can see, those arrears started accruing in 2019. His position is that Marnie switched up her position and how she was notifying him. She used to send it to his mailbox. She stopped sending it to his mailbox. I guess she may be sent through email. We don't know, but he gets hundreds of emails a day as a business owner. So that is how that 1 year of bills accrued.
So his position is he gets hundreds of emails and he doesn't want to do a search for hers, which you could put in a search bar and say anything from her at any time. Once a month he could have looked at those, or once a week he could have looked at those, and not even had to look through the rest. But my question is, if he doesn't look through his hundreds of emails for his business, wouldn't he have seen them?
Well, I'm not saying that she sent them or didn't send them. That was her argument, was that I emailed them to Victor.
Okay, and he said
His
he didn't. I
position was
remember the
I
last time,
didn't.
counsel, your client said he didn't want to get them through his email because he gets hundreds as well. I remember that from the last hearing as well. He was still providing.
Right,
If he was
and
still
so-
providing them their due.
I'm just saying she went outside. We're not arguing that they're due or not.
Okay.
We're arguing about how much is owed.
I would say it'd be the
100%
one half.
of
It'd
the
be
medical
one
bills?
half. It'd be one half of the amount. That would be what it would be due. It's going to be the 30-30 rule. If you're going to fight over those kind of things, I think you're wasting a lot of time and money. It'd be the half of what she paid.
Okay.
I mean, but like I said, I don't have evidence before me, so I'm just telling you how I think to get you guys to resolve this. You
Understood.
understand that? Because I'd
And
have
I
to make
appreciate
findings of all
that.
those issues if we're going to go to trial.
Right, of course. But then, so part of our negotiations included attorney's fees because, she had been asking for these monies. She was forced to come before the court. And then even after coming before the court, she continued to accrue more arrears, which is why we did a second schedule of arrears. And that's
I understand.
where
She would be entitled to attorney's fees if she's having to track him down to pay one half because he doesn't want to look at his emails. And if once he knew he got it, I would grant her attorney's fees. I just don't know what the amount would be.
Okay.
I mean,
And
I
then
don't
the third issue that's
Okay.
just kind of arisen at the very end of discussion was Victor was not ordered before to pay the child care. And correct me if I'm wrong, Franny, but so he made the stipulation in March, trying to be a good guy, like, hey, I'll help pay for some of this family care. I'll pay half. He's saying now he doesn't want to pay half of her child care on her time, as his business has taken a hit with the recession that we're currently in.
Okay, so is the issue is it certain days are her days and certain days are his days, and he wants to pay on his days and not on her days? Is that what I'm hearing?
Well,
No.
to be fair, my client has primary physical custody and
Right.
is caring for the child 6.5 days out of the week.
Mhm.
So she has doctor's appointments. She has a mother who has cancer. That's one of the issues. She's providing care to her mother. And so now with coronavirus and the child not being in school, when Marnie is going to visit her mother to provide care for her, she has to bring in a babysitter to watch the child because she's only 11 and she's not comfortable leaving her alone at the house. So my understanding, my position would be, well, he stipulated to pay these expenses at the last hearing as a stipulation. You know, her having to be responsible for the child 6.5 days out of the week, there's a lot of third-party caregiver expenses associated with that.
Counsel, let me ask you this though: what was he stipulating to a certain amount, which now has been increased because your client is having to go take care of her mom and she has the child in her care? Have they increased because of that? Is that what the problem is? Is this increase?
That I'm not clear on that, but we've already agreed that the additional costs that were incurred for her caring for her mother, it was only on 2 occasions, and that she'll remove that from our family wizard reimbursement request, and that's fine moving forward. That could be it, but.
Well, this is the concern. He made a stipulation based on a set amount or a set idea of what it was, would be my assumption. Because he wasn't going to make it going forward that she could change her life and make it all the time. She has primary physical custody for lots of reasons, I assume, you know, without going through all the detail and minutiae of the case. But what he agreed to was what he agreed to, counsel, and unless he files a motion, if there's a real reason to change it, I don't see there's a reason to change it. If he's now available because his work's been cut back and she needs some help taking care of the child, maybe that's part of it. Maybe he has more, maybe he helps out and it's not considered his time or her time, her time's her time, his time's his time, and maybe that reduces the cost. But I'm not going to attack him with additional costs if it's because she's doing extra work taking care of her mom because, and now we're to summer. This is something she would have foreseen anyways, right?
Right, and maybe it's also because, Your Honor, that the child hasn't been in school, possibly, and she's using caregiving more. I have no idea. But I think the court's probably correct in saying he was anticipating a certain amount, and it's now higher.
Well, that becomes a question for the court, and I don't know the answer to that from what I have before me. But as far as summer goes, you all were expecting summer. Whatever the summer schedule, you're all expecting summer. I assume this week is the last week, or last week was, whatever. Now, moving forward, I'd say that is what you all expected. Part of
Mom's
whatever that was.
Mom's a school teacher. Mom's a school teacher, so she doesn't work in the summers.
Okay. Well, and it was based upon that. I mean, I don't know. So now she's caregiving for her mother. So, counsel, are you asking for anything moving forward, Ms. Risch, as far as the summer goes, or just half of what they normally would be doing?
Requesting to confirm that prior stipulation. And we've already stated that, like, the caregiving for her mother would not be included in that.
Well, he did make the stipulation, counsel, and you'd have to make a good argument why I shouldn't tax him with that, because that was his agreement. I'm certainly not going to allow it to be extra because she's doing this other stuff, which they've already stipulated that wouldn't be the case. I wouldn't be inclined unless you could prove some real hardship of why that is, and then I'd tell him, look, then you step up and take care of the kid on the daycare days. That's the other option, right? So, and I wouldn't consider that a change of custody. If your client doesn't want to pay the part that he stipulated to, then maybe he takes care of the child on those days, and I still attribute it as mom's time. That's the other way we'd do it. Because I don't know, you're saying his business has reduced so significantly. Is that right, Ms. Robinson?
Yes.
Okay. Well, based on that part, I would say if he has all this free time now that his work isn't going forward much, then maybe he takes care of the child, and that offsets part of the added cost. I don't know. I don't know the answer to that, counsel, because I don't have all the facts before me, but that would be my inclination. If that's the case, he would have to have a real reason, and then if he has less work, then maybe he steps up and takes care of the child on those days that they were paying for. I don't know. We're just, like I said, discussing possible, since this is more of a, you haven't got a motion before me, but that was our stipulation last time was defendant shall pay half the cost of the child's child care expenses, fees. But I would limit it to the ones that they had existing, not added ones because mom's taking care of grandma.
Okay.
Does that help anything?
I think that helps.
So those are the only agreements you have. So this is what you have left. Are those things? Do you guys want a status check? And you guys, now that you have a little inclination of what the court could do, even if it's a week from now or 2 weeks from now, to get it worked out, or how would you like to proceed?
What time would the court be coming back from lunch? I think everybody just kind of wants to get this done today, so I figure if we go another 2 weeks, it just maybe
could we come back on the record an hour?
We'll unravel some of our agreements.
How about if we come back on the record at 2 o'clock? That gives you, gives me time to let them have lunch. It's 12:30 now, and lets me have a chance to go respond to things I need to respond to. Come back on the record at 2 o'clock.
Will that work for you, Francesca?
I think I have something at 2, actually. Yeah, I have a client coming in to sign something at 2.
If it's sign something, counsel, do we need to do it at 1:45? Or we can do it at 2:30. If it's just a client that's signing, I can do it at 2:30.
1:45 would be perfect.
Okay, we'll do it at 1:45.
All right,
Okay.
Francesca, if you wouldn't mind staying on the line, so maybe we can resolve now, and then everybody meet back up at 1:45.
Okay, we'll come
We
back on the
appreciate
record at
it, Your Honor.
1:45. Okay.
Thank you for
Perfect.
talking to us.
Thank you.